So thank you very much for joining me in this video. I had an interesting conversation with an agent this week involving spousal consent and a matrimonial home. I want you to imagine that a single fellow owns his own home. It's his principal residence, and over time he's living there, and over time he gets married. His wife moves in, and they live together in this house for, say, a number of years. But then the marriage gets a little bit rocky, and they separate, and she leaves. The question is he free to sell the house? Bear in mind that it was in his name prior to the marriage, and that it's only in his name. The answer is no. And the reason is the Family Law Act. I think of the Family Law Reform Act, but this is the Family Law Act that followed it, 1990. And it states that the matrimonial home cannot be encumbered or disposed of without the consent of the spouse. Not getting into the equity, it's not getting into prenup agreements, anything else. Straightforward, it can't be disposed of, it can't be encumbered. So, and then I should mention, this also applies while the marriage is still intact. In fact, they're anticipating a situation where possibly the wife is under a very dominant spouse, and he wants to take the equity out of the house, and he's just going to force his way and put a large mortgage on it, 90% mortgage on it or 80% mortgage on it, and all her equity is dissipated. And so it's required that she get independent legal advice, not sitting there with the husband there, not sitting there with the husband's lawyer, independent legal advice to confirm that she is willing to have the property sold. I remember a situation that happened when I was very early in real estate. I wasn't personally involved, thank goodness, but I was aware of it. There was a dairy farm, and it was a fairly prosperous dairy farm. The husband and wife worked hard at it over the years, and then they separated. After they separated, the husband decided that he was going to sell the farm. And of course, a lot of equity tied up in the farm. He didn't request or obtain his wife's consent. He was supposed to have, he didn't. And it was buried in a corporation, a farm corporation. He sold the farm, and then the wife was left out in the cold. Well, she wasn't living there, but with no equity, no money, he grabbed it all. And so she hired the most expensive and most ruthless lawyer in the area and sued him. Well, it dragged on for a long time in court, and eventually she won. The problem was that the lawyer took all the winnings, all the award, as his fees. She ended up with nothing. She committed suicide. Very sad story, but it indicates what happens, what's at stake, and what can happen if you overstep the Family Law Act. So, upon separation, if there isn't a separation agreement you need, or a court order, then you must get their consent. If you take a look at the listing agreement and you take a look at the agreement of purchase and sale, it's built right in there. What it says on the listing agreement, number 10, it's under Family Law Act. It says the seller hereby warrants that spousal consent is not necessary under the provisions of the Family Law Act 1990 unless the spouse of the seller has executed the consent herein provided. And then down where you sign, they got something called spousal consent, and they say the undersigned spouse of the seller hereby consents to the listing of the property herein pursuant to the provisions of the Family Law Act 1990 and hereby agrees to execute all necessary or incidental documents to further any transaction provided for herein. That's the listing agreement. So when you're listing the property, you get the spousal consent to put the property on the market for sale. You market the property, and then you get an offer, and on the offer, there's provision in the offer either to state that the spouse consent is not necessary or a place for the spouse to consent. And in fact, it's the same thing in the agreement of purchase and sale that it says in the listing agreement. It says under the Family Law Act, number 22, under the agreement of purchase and sale, seller warrants the spousal consent is not necessary to this transaction under the provisions of the Family Law Act 1990 unless the spouse of the seller has executed the consent transaction provided herein. And then under spousal consent, it says the undersigned spouse of the seller hereby consents to the disposition evidenced herein pursuant to the provisions of the Family Law Act 1990, and hereby agrees to execute all necessary or incidental documents to give full force and effect to the sale evidenced herein. So they're either saying it's not necessary, or they're providing it on the listing, it's not necessary, or they're providing on the sale. Now, you say, what happens if they refuse to sign? Well, you can't sell the property unless they sign, in spite of there being a prenup agreement, because the prenup agreement can't overstep the matrimonial, overstep the Family Law Act. And the fact that it's pre-owned doesn't change the fact that it becomes the matrimonial home. So you would require, if you can't get the signature, if it's not tied up in the provisions of a separation agreement, then it needs the court order. And we're not talking disposition of assets. The spouse is entitled to half the equity in the home, but that may be factored out in terms of family assets, in terms of support and all kinds of other things as to how the money's divided up. That's not really your or my problem as realtors, but we've got to make sure that we've got the express consent so we don't run into the kind of problems. And I certainly wouldn't want to have been the agent involved in that farm I told you about, didn't do the homework right. Thank you very much. Appreciate your time. Talk to you again next week.